From the National Association of Consumer Bankruptcy Attorneys, this is NACBA Now, with your hosts Gene Melchionne and Jim Haller, discussing bankruptcy law for the busy consumer bankruptcy attorney.
Hello, Gene. How are you doing today?
It's another day, and today it's rainy, so I'm inside.
All right. All right. Well, we are here to talk about the Caselaw update published on September 7th, 2023. Some interesting cases. The first one is In re Pressman from the Bankruptcy Court, Southern District of New York. In this situation, it's kind of an interesting situation, but first of all, I'll say this. This was successfully argued by NACBA member Roy Lester of Lester, Kornman, Cameron, and Massini PC in Garden City, New York. So congratulations to Roy.
Good job.
Yeah. In this situation, the debtor filed a Chapter 7 bankruptcy. There was a pair of creditors that were considering filing a non-dischargeability lawsuit, and they and the debtor's attorney and the debtor agreed to two continuances of the deadline to object to discharge, and then the creditors fired their attorney, and they blew the deadline. The attorney actually wasn't allowed. Their attorney wasn't allowed to get out for about another month after the deadline passed, but the creditors themselves, pro se, filed a motion to extend the deadline, and they argued that their attorney didn't extend it again, so it's his fault, and the attorney didn't tell them about the deadline. And what do you think of their argument?
It was a pretty poor argument, I have to say. Having been on the creditor side of things early in my career, this was a tactic that I would use all the time to file a motion to extend the time to file a non-dischargeability action, which always would drive the debtor's attorneys crazy because it held everything up. And I always had to be very careful to pay attention to those deadlines. Mm-hmm. And clearly there was something going on in the background here between the debtor's attorney the creditor's attorney and the creditors.
Yeah.
But this outlines, if the pro se creditors were correct, then all they did was outline a malpractice claim against their former attorney. Has nothing to do with the bankruptcy or the discharge or the non-dischargeability. So I followed this along and I said, well, that's exactly what should happen.
That's right. And the court repeated the rule that we've often heard, that the failures of counsel is not grounds for relief.
Right.
And that you hire a lawyer, well, you're responsible for their acts and omissions, and you're also held to know what that attorney knows. Anyway, very interesting case, and good job to Roy for arguing it and winning.
And well, he should have.
Yeah. This next case is called In re Icor. It's from the District Court of Southern District of Texas. And in this situation, it's kind of a interesting interplay of rules here. Prior to the bankruptcy being filed, the debtor had signed several agreements to transfer real estate over to the creditor, and the creditor had initially filed an action essentially to foreclose on that property before the bankruptcy was filed, but the debtors were not served and it wasn't completed. The debtors filed bankruptcy and went through. There was no discharge issue going on. The debtor received his discharge, and then after discharge, the creditors, they properly served the debtor in essentially this foreclosure proceeding, and and got an order transferring the property. And the debtor went back to bankruptcy court and said, "Hey, you can't do that. You're basically perfecting a security interest on my property." And the creditor came back and said, "Wait a minute. The discharge injunction prevents in personam cases, but not in rem cases. And so we should be able to go after our collateral." So the bankruptcy judge had to make a determination whether or not this situation to essentially quiet title and determine who is the owner of the property was a violation of the discharge injunction. Thoughts?
Again, another one of those no-brainer kinds of cases, because they knew about the bankruptcy, they had the knowledge, they were notified, and they waited until after the discharge entered before they proceeded to get a default judgment. They knew what they were doing. They didn't do it right, and as a result, they lose.
That's right. So, and the important thing I think in this situation, the way what I take from this, distinguish it, is this is different than your standard mortgagee type case where the security interest is well established before the bankruptcy is ever filed. In this case, the big issue was, was this contract signed by the debtors and the creditor a legally binding security agreement? And that was the problem. It wasn't. And so
it was a contract for sale.
Yeah, and you can't go fix it afterwards, after the discharge. So another interesting case. All right, next case, Inri Guy out of the Bankruptcy Court for the Western District of Pennsylvania. Interesting case. The debtor's bankruptcy was ultimately converted from a 13 to a 7 without a confirmed plan and with arrears in the plan payments. Gene, why did the judge do that in this case?
To me, this seemed to be more of a disciplinary kind of thing against the debtors, that they were using the bankruptcy as a stalling tactic of some sort. I've seen Chapter 13s not go to confirmation easily for more than 6 months or 9 months, which was somewhat the period here. I've also seen cases where the Chapter 13 plan payments pre-confirmation were in default and not had the case converted to Chapter 7. But there's something going on behind the scenes here where I clearly got the sense that the judge was not happy with the debtor's actions here, and it was sort of a disciplinary kind of a conversion to a Chapter 7. Let's get this thing done, and there's no hope of a reorganization and payments here because they just weren't happening.
Yeah, and the impression I got from this case is that the debtor's attorney would show up on motions to dismiss the case and say, "My clients have told me that they're going to sell this property and the money's all going to be paid up. Just give us, 30 more days." It kind of reminded me of that scene at the very end of the Animal House movie where he goes up, "Dean Wormer, can we just have one more chance?" And eventually the judge says, "No more chances." And so interesting case. This next one is interesting. I haven't seen this come up in my practice, but the debtor had he worked for a Canadian university, and when working for that Canadian university, he qualified for a Canadian retirement account. And then he came to Chicago, filed bankruptcy, Chapter 7, and the Chapter 7 trustee objected to the exemption, saying that it wasn't an internal revenue service qualified retirement vehicle. And they argued back and forth about, does it apply to foreign deferred compensation plans? And the court came squarely down and said,
"No, it's not.
No, it's not.
No, it it meets the definition of a retirement plan, but not a qualified retirement plan, and there's the difference. So, interpretation of Canadian law and the interaction with U.S. law, but this is the U.S. You follow our rules.
Interesting case. So in this situation, if you had a client who had that, what would be the way to try to protect that before the bankruptcy was filed?
I haven't come across the situation. I'm not really sure how I would do it. Maybe find a way to convert it somehow to, a qualified plan, or liquidate it somehow and turn it into some other kind of asset.
Yeah.
It's a tough one. When you talk about the IRS and anything, things get complicated.
Right. Yes, absolutely. I don't have the right answer on it either, but I would think I would look at that first thing you mentioned really hard, seeing if I could roll it over into a qualified retirement account without causing any issues on that.
Right. And to think before I became a bankruptcy lawyer, I wanted to be a tax lawyer.
Right. Yeah.
Never going to happen.
So the next case is kind of interesting. Again, Northern District of Illinois Bankruptcy Court. And I put this in just because it was an odd situation dealing with interest rate that a secured creditor is entitled to receive, or I should say a creditor is entitled to receive in a Chapter 7 bankruptcy. In the case, the case was closed and then reopened to administer an asset. And the creditors all filed their claims, and the trustee filed his notice of proposed distribution, and the city of Chicago objected. And the issue was, what interest rate should they be paid on their claim from the start of the bankruptcy until the time the money was dispersed? And the trustee argued that it was the federal judgment rate, which would be about 0.1%. And essentially, for the time they had waited, they'd receive a whopping $43.54. Yeah. The city objected, saying, no, it's 9% interest under Illinois law, in which they would receive $2,807, so significantly more. And the court came down and said, Illinois law prevails in this situation. And I thought that was an interesting situation. I just mentioned it because it deals with interest rates, and but it talks about what is the the controlling law and what is the legal rate when it comes to this particular issue. So
I've come across this issue many times in Chapter 13 cases in Connecticut, where the municipality files a claim that's secured by the property, and the state law provides for an interest rate that's way higher than the federal judgment rate, and you have to give the municipality that state law rate, whether you like to or not.
So interesting case. Just to keep that in your back pocket and be aware of that when we're dealing with clients with these kind of debts. So
right.
Well, Gene, it's good to see you. Thanks for joining me today, and we'll be back soon with another case law update. Thank you, everybody.
Okay, we'll see you around, folks.
Thank you for listening to NACBA Now and your continued support of NACBA. You can find additional materials to assist you on the member dashboard page at NACBA.org. Educate, advocate, litigate. NACBA.